All righty, let's get started. We're going on the record on cause number DC 23-17209, Mendoza versus Great Brothers Electric LLC. Counsel, make your appearance.
Good afternoon, Judge Marilyn Law, representing the plaintiff, Great Brother Electrical Service, and the counter defendant, Josue E. Mendoza.
Yes, Ryan Baker with the NACO Law Firm for defendants, Your Honor.
There's a Stephanie Huerta on here. Is she involved in this case or?
Not that I'm aware of.
Miss Huerta, what are you here for, ma'am?
Actually, this is Jose is over here. Jose Mendoza.
Oh, okay.
Yes.
All right. Well, let's get going. You may proceed.
Thank you, Your Honor. I have filed a motion to conform an arbitration award that was issued in this case on September 8th by Mr. John Shipp, and then to confirm the award once conformed. I think all parties agree the arbitration award was final on the part of Mr. Shipp. He addressed all of the issues before him, and therefore it is appropriate for the court to confirm the award in the event that neither party has an appropriate appeal. I filed my request for the court to conform the award under section 171.091 of the Texas Arbitration Act, which states that the court shall modify or correct an award in the event the arbitrators have made an award with respect to a matter not submitted to them, and the award may be corrected without affecting the merits of the decision. In this case, if you'll recall, you executed an order compelling us to arbitration with Mr. Shipp. Mr. Shipp decided to institute baseball arbitration to resolve the dispute. And in his award, he described that as the most efficient way to resolve this dispute, and that he would choose either the Mendoza agreement or the Perez agreement as the final settlement agreement. He asked each of us to submit our best settlement proposal possible. And he stated not only in his award, but then in 2 emails to each of us in conjunction with preparing for this arbitration, that he would, quote, simply pick one over the other as a final settlement agreement between the parties. And then in another email, he said, I will also note there are things each side doesn't like about the other side's agreement. Pursuant to my mandate to resolve the dispute, I am picking one agreement over the other, which is
Objection, hearsay.
I submitted this as Exhibit A to my motion, Your Honor. It's the email from Mr. Shipp. And if necessary, I can testify. This is the email I received from him, as did Mr. Nacol.
It wasn't offered into evidence, Your Honor. I'm still going to object to hearsay at this hearing.
I'll offer it into evidence at this time as the rules the arbitrator set forth to govern.
So is this included in your briefing? I don't remember this. Is this included in your briefing?
It is, Your Honor. It is Exhibit A to our reply brief.
And when was the reply brief? I don't think that, let me see. There it is. Okay.
And the first one I quoted from, Your Honor, is Exhibit 1 to the motion itself.
All right, I'll just take notice of the file.
Okay. He states, pursuant to my mandate to resolve the dispute, I'm picking one agreement over the other, which is a binary decision, and one side or both may be unhappy, but it will bring resolution to your dispute. All of that leads to the basis for my request to modify the award. Mr. Shipp selected the Mendoza agreement as the one he picked, but he then went on to attempt to modify the terms of the agreement contrary to the rules he had set out for us when he stated in his award, the mediator finds that the mediation agreement intends that Mendoza on one side and Perez on the other were responsible for paying their own fees. And in the award itself stated, Mendoza and Perez are responsible for paying their own costs, attorney's fees, and arbitration fees in the above styled matter pursuant to the Mendoza agreement and through the end of this arbitration. Now, My contention, Judge, is because he put pursuant to the Mendoza Agreement, the terms of the Mendoza Agreement, which has now been signed by both parties, prevails over this preamble clause in the award. But I don't want any dispute, and Mr. Nacol has indicated he does not agree with my interpretation of this provision. The Mendoza Agreement states all debts of the company shall be paid from either the proceeds from the sale of the property, which has now occurred, and those proceeds are sitting in the registry of the court, or in the event there is a deficiency, each party must make a capital contribution to the registry to pay the deficiency up to ultimately zero, a balance of zero. The debts of the company include the attorney's fees my client, as the controlling member of the company, incurred in this matter, prosecuting its claims in the winding down process. As you may recall, the parties enter into an agreed adjunction appointing my client as the controlling member responsible for winding down. And the laws that govern the winding down process state that in that role, he had the authority to bring a suit to protect the assets of the partnership. He did that. The company incurred debt. Mr. Mendoza, in part, contributed and paid some of that debt in advance on behalf of the company, and there is a liability outstanding against the company for additional fees. That is the nature of the dispute. In reading the law, which allows the court to modify the award, it states that an award can be modified if it does not impact the merits of the case of the award. I sent the court, I cited the court to In Re SMH at 523 Southwest 3rd 783, which is actually a case involving baseball arbitration. I also cited the court to an authority on baseball arbitration and what that term means. In the case I cited you to, Judge, the arbitrator elected a settlement agreement regarding support in a divorce proceeding, but then went on to—
In that case, was baseball arbitration mandatory, or was it? Because this case, I think he was coming up with a proposal on how to do it. It wasn't, you guys did not agree to baseball arbitration. That's just what he kind of instituted, right?
Mr. Nacol agreed to it. I had concerns with it and voiced those.
Your Honor, there was no
It-
agreement regarding baseball arbitration. We have the agreement that Mr. Shipp sent to councils, and baseball arbitration is not mentioned in this agreement. And I'd offer that as Exhibit D5 into evidence, and I can share my screen.
Was that included in your briefing?
That was not included in the briefing, Your Honor.
And Your
So my
Honor,
recollection was that we had a hearing on this, I recall, in the courtroom about there was a fairly short provision that said that any, I don't remember the exact terminology, you can probably read it to me, any disagreements that arise out of this agreement are going to be decided by Mr. Shipp, right? It did not discuss baseball arbitration.
it did not, but it did state, Your Honor, that each party will be bound by the rules established by the arbitrator. And in his email to the parties prior to the arbitration proceedings sent to us on August 28th, he specifically set out the rules and said, as we discussed, we will be conducting baseball arbitration. I will be looking at our original settlement agreement and the two proposed final agreements, and will simply pick one over the other as final settlement agreement between the parties, which should encourage both parties to submit the most reasonable interpretation of our original settlement agreement. He specifically set out the rules in his August 28th email to us, and that's how it was conducted.
And Your Honor, I would submit another email as Exhibit D6 from John Shipp on September 5th, 2024 to the councils of both parties, where after Mr. Nacol asked what he wishes to hear regarding the positions of the parties, I quote, Mr. Ship says, I want to give both parties an opportunity to tell me what they want to tell me. And it's our understanding of case law, specifically Gordon versus Nickerson, that an arbitrator may expand its scope of its review based on the issues the parties submit or the arguments they advance in the proceedings. This issue was brought up at arbitration, giving Mr. Ship power to make a determination on this issue. I would also submit, Your Honor, Exhibit D2, which was attached to our filing, and it is this court's order for arbitration. And in that order, this court specifically stated it is ordered that the pending dispute between all parties regarding the interpretation of the settlement agreement be arbitrated. That provision specifically gives Mr. Ship the power to make a determination regarding the terms of the mediated settlement agreement. Another exhibit I would like to submit is Exhibit D1, which is the mediated term sheet. And specifically on page 2 of the mediated term sheet, it states, parties shall pay their own attorney's fees. Mr. Ship simply clarified this issue in his findings and in the award by including the term fees for arbitration. He included that in there. That's the only discrepancy that was not in Mr. Mendoza's sheet that, or their final agreement, which Mr. Ship did choose, and he attached that to his findings as well, or to his award as well, excuse me.
Several important points, Judge. The portion of the email he read to you is followed by Mr. Ship's statement that he will be conducting baseball arbitration and will be choosing one agreement or the other. He did not reserve anything for himself beyond that. And in the SMH case I cited you to, the court says, when you opt to conduct an arbitration through baseball arbitration, you cannot change the terms of the settlement agreement you pick. You have a binary choice, this agreement or this agreement. The terms of the mediated settlement agreement are completely supplanted by this agreement. That was the whole purpose of this. It is no longer binding and no longer exists. Most importantly, Mr. Ship himself, again, binds himself strictly to the binary choice in his actual award, where he states, I am instituting baseball arbitration and choose the Mendoza agreement or the Perez agreement as the final settlement document. And that was done in this case. His own award acknowledges he's doing that. He did not reserve anything beyond that as authority. So there's no basis to go beyond that, particularly because the Mendoza agreement addresses the issue of attorney's fees in two different places, as the debt of the company, and then in paragraph 9 specifically, it acknowledges attorney's fees are to be paid to the prevailing party. He cannot contradict the terms of that agreement under the case law I cited you to and the terms of baseball arbitration once that method of arbitration has been selected by him.
Okay,
In your
guys,
honor.
just a second. No, just a second, Mr. Baker.
Yes, sir.
So there's been a lot of briefing. The purpose a lot of times of this arbitration is to try to streamline things. I don't know that it always does. This case is still open, officially open, and there's a non-jury trial coming up on October 22nd. I'm a little unclear at this point, Mr. Baker, what is it that you want me to do?
We would like for the award that Mr. Ship sent to the parties, which all the parties have signed at this point on September 10th and September 12th. We would like that award to be confirmed and
And have you submitted a proposed order confirming that award? And if so, what day?
Yes, we submitted it this morning and sent it to
Is that this right here that was submitted this morning? Let me show you this. Tell me if you can see it.
And I have not had an opportunity to review it yet, Judge.
Yeah.
I just got it like an hour ago.
Yes, Judge, that is it. And the award that Mr. Ship sent to the parties is attached to that order as Exhibit A and referenced in our order. The only thing different in our order that we submitted is we removed language of the award being interim.
And I'd like an opportunity to review that and assert any objections, but more importantly, I think I've presented
But Ms.
appropriate.
Laura, so this is your chance to make objections. So do you have any objections to the form of this order?
I haven't had a chance to even read it, Judge. I just got it an hour ago while I was
Yeah.
preparing for the hearing.
I don't know if you usually practice in federal court or what. In state court, usually orders are signed at the time that the hearing occurs, and I'm going to sign an order now. So if you have an objection to this order, I'd love to hear it so that I can make any modifications of it. It's only a 3-page order. If you
Yes,
don't have an objection or you just don't like it, I'll just sign the order
no,
as
that
is.
is not, and I have a proposed order to submit to the court as well,
Yeah.
Judge, but hang on.
I'm not signing your order. I'm going to sign his order, but if there's a specific objection you have, tell me now before I sign it.
Yes, let me get it pulled up. Give me 1 second to find it.
Well, it should be on the screen if you can see it.
It is not on the screen. I've got a whole list of things. Sorry, I'm trying to see what's on here. Let me see if I can open it myself. I cannot.
I can share my screen, Judge.
Okay, and I'll do it again. Let me show you.
There it is. Okay, can't see page 1, there we go. All right, let me get here, Judge. Give me 1 minute. Well, I mean, to start with, it's plaintiff's motion to conform and confirm the order. The defendant does not have a motion on file to confirm the award. The arbitration award signed on September 8th is confirmed. Well, obviously, I object to that, Judge. You know my.
Okay, I'm asking about, I know you don't agree with the ruling, but I'm just trying to get if there's an objection to the form.
Yes, the Mendoza agreement does not state each party shall pay their own attorney's fees. That is on, I can't tell what page I'm on here.
Page 2. What paragraph are you looking at?
I'm in the findings.
Right here.
I'm on page 2. Yes, go a little bit lower right here. Can you see me?
The mediation agreement states that the parties shall pay their own attorney's fees.
No, down two lines. It begins, the Mendoza agreement states each party shall pay their own attorney's fees. That is not accurate.
And
That is
Judge,
not what the agreement states.
if you scroll down to Exhibit A of this order and go to page 9 of the interim order of this, if you keep going, Judge, it's number 6.
Is this it?
Yes, 6. If you read the last sentence of section 6, each party shall pay their own attorney's fees.
Okay.
Hold on, whoa, hold on. Yes, that is correct, Judge. And this is the provision where each party shall pay its own attorney's fees. There are 3 parties in this case. Mr. Jose Perez, my client, Josue Mendoza, who brought no claims but was sued as a counter defendant, and the main party in this case, Great Brother Electrical Service. And this is the where everything has gone sideways. If each party is going to bear its own attorney's fees, Great Brother Electrical will bear its own attorney's fees. I have those fees. I have those bills for the company. The company has paid part of them. They haven't paid all of them. They would be required to pay their fees because there's not enough money left in the registry of the court under the Mendoza agreement. The parties are obligated to put money in as a capital contribution to make up the deficit. That is correct.
Judge, I would also like to state that in the in the award, the parties are defined, or in the settlement agreement and mutual release, the parties are defined on the first page. And there's 4 parties acknowledged here. And throughout Exhibit D1, which is the mediated term sheet, the arbitration award, everything states each party shall pay their own attorney's fees. And so
I've never disputed that. It does state that each party, in legal terms, a party is a party. And in this case, if you look at the first paragraph of my settlement agreement, the parties are identified. Great Brother Electrical Service, my client, Josue Mendoza, because he was sued as a counter defendant, Mr. Jose Antonio Mendoza.
Mr. Ship, though, he discusses your argument here, right? Can you see this page? It says, for the first time at the hearing, counsel for Mendoza claimed her interpretation of the mediation agreement, the Mendoza agreement, was that Perez's fees were the responsibility of Perez, and Mendoza's fees were a debt of Great Brother, as Mendoza's claims were brought derivatively against Perez individually, despite Mendoza also being sued individually and Perez also bringing derivative claims on behalf of Great Brother. This position is not explicitly stated in the Mendoza agreement or the Mendoza briefing. The arbitrator finds this interpretation unpersuasive. So you already made this argument to the arbitrator, correct?
Yes, correct.
All right. So this is you're just trying to re-argue this. I'm just asking, there's no issue as to the form of this.
Yes. Well, I haven't gotten to the rest of it yet because we switched over to the settlement agreement. So if we can pull it back up so I can look at the rest of it. Is this it? Am I looking at it?
Mm-hmm. Yes. Give you one more chance to make an objection as to form, but if you just wanted to keep arguing the merits, I've already decided the merits. I'm going to enforce the arbitration, Mr. Ship's award. Any other objections?
Well, it just flipped again, Judge. Let me look at this last page. It keeps flipping before I get to the end of it. Okay, now I can't move the page. What is happening here? I cannot move the page, Judge.
You want me to go to the next page?
Yes, please.
Okay.
Thank you. I don't have any objections to the language used here. The other issue I raised in my motion to confirm was to attach Exhibit C, which was part of my presentation to Mr. Ship, but he did not attach Exhibit C to the final award. It is referenced in my Mendoza agreement as well as in the other agreement in this case that was presented. And I would ask the court to attach that for completeness.
Response.
Yes, Judge, one moment. Let me make sure I'm looking at the correct. And you said Exhibit C.
Yes, it's the list of clients Mr. Perez submitted.
Which I believe is also attached to the final settlement agreement.
It
correct?
somehow did not get attached, and I just want to make sure it's attached to the award and any judgment.
I saw it in there. Let me double check. Let's see. Yeah, she's right. I don't see the list. I don't know if it needs to be in there, but I don't see the list of.
It does, Your Honor, because it is referenced as the clients against whom Mr. Perez has to indemnify Great Brother and Mr. Mendoza. It's the list of clients Mr. Perez owns.
Response.
I have no objection, Your Honor. I'm assuming that was a mistake. That's been the list that was agreed to, I believe, throughout this. these disputes after the MSA was signed.
Well, let's see if I want to get this order signed. So where is
It's
where is
attached
this list?
exhibit,
Whoa, let me finish, okay? So where is this list found in the court's file?
attached to my motion to conform. It's an exhibit, I believe it is exhibit 3. And it looks like this, Judge.
Let me do this. I'm gonna share screen this.
It looks like that, if you can see it.
Exhibit, what number is it? Exhibit
3.
3 attached to plaintiff's motion to confirm, is that right? Or motion, what was the motion called?
Conform and confirm.
Filed what date?
Hold on.
September 13th.
Is can you see this okay?
I can see what you typed in there, yes, as
Exhibit
attached.
3 attached to plaintiff's motion to conform and confirm, filed on September 13th, 2024 is incorporated exhibit 3 to this order.
Okay,
All right.
can you
Anything else, guys?
can you move it? Should it be above the signature line, or is there not room for it?
There's not room.
Okay,
That's it from defendant, Your Honor.
yeah,
Anything else?
nope, that's it.
All right, guys. And so this close this, or is it going to be another order that a final judgment that we need to wait on?
We're going to be presenting an order to pay out from the registry of the court the proceeds.
Yes, Your Honor.
Right, but does this close the case, the order confirming, or are you doing a separate judgment?
I was planning to submit a separate judgment, which I've prepared, which will include everything, including the transfer of the funds from the, or the payout of the funds from the registry.
Okay, Rhonda, are you there?
Yes, Judge, I'm here.
Make sure Marissa knows not to close the case until we get this final judgment. You could just
Okay.
And Judge, when I submit the final judgment with the payout,
I'd like to do that as an agreed order or agreed judgment.
that's what I was going to ask. Okay.
All right, guys, anything else you want to chat about?
I don't think so.
No, Your Honor.
All right, you guys have a great rest of your day, okay?
You too.
Thank you,
Thank
Your
you.
Honor.
Thank you.